Hi, my name is Diana Chavez. Thank you for joining our webinar. SunRay secures $10 billion annually for GC subs and suppliers. We're a national construction document service. Today, we have a great Kansas webinar on getting paid faster with liens, bonds, and contracts by the amazing construction attorney, Leslie Baugh. Without further ado, I would like to introduce Leslie Baugh.
Thank you, Diana. I'm happy to be here today and talking about this very important topic for our clients within the construction industry. First up, before we dig in, I'd just like to figure out how to change the screen. There we go. If you have any questions during the webinar, just go to the chat box on the right, and we will address all the questions at the end. And when you fill that out, don't include your name or company name. Just ask your question, and we will address that at the conclusion of the webinar. And with that, we can jump right in. So there are several tools that we've talked about on various webinars with SunRay to help you get paid. If you go back and search the SunRay webinar website, you'll find talks I've done on mechanics liens, bonds, and also even one specifically just on contracts. So today, what I'm really going to try to focus on is how we use these tools, not just to get you paid, but to get you paid faster. And when we address this topic, I always like to distinguish the difference between getting paid fast and getting paid faster. So just because we might be using all of our tools to protect our right to get paid and get paid quickly, it doesn't necessarily mean it's going to be as fast as we want. But if we do use all the tools appropriately, we'll certainly be getting paid faster than we would have otherwise had we not been utilizing the tools at our disposal. So as we all know, the typical payment process on a construction project involves various layers. So we've got suppliers and equipment vendors, subcontractors, subcontractors, and everyone's submitting their request for payment up the contractual chain, where it then will eventually land on someone's desk at the owner's office or their lender if they're also providing some services with that regard. And then once payment's issued by the owner, it then has to also trickle down. So it'll go to the original contractor, then disperse to subcontractors, and finally to their suppliers and vendors. And because of that process, it can take time to get paid. And one of the key things we like to highlight with all of our clients is having some systems in place and triggers and red flags in your systems that will help you be aware of what you need to do when to both protect your right to get paid and maybe get paid more quickly. And as I'm looking back at the name of this webinar, I realized I probably should have called it the contract liens and bonds as opposed to liens, bonds, and contract, because it really does all start with your contract, both when you're negotiating it, but also understanding it and following it to position yourself properly, both to get paid, but also to get paid promptly. And then when problems arise, knowing that you've done all you can to protect your right to get paid. So really, one of the keys that we have here is don't wait. The old adage of the squeaky wheel gets the grease is completely true in the construction industry. If any entity is feeling any financial strain, it's the one that's bugging them that's going to get that first check cut to them. So we always advise be loud, be prompt, and bring attention to your situation if you're not getting paid. So first, starting out with your best practices to follow with your contracts. Again, we have previous seminars that will go into a lot more detail and a lot more important contract provisions that play into protecting your right to get paid. But what I'm really going to try to focus on today are key provisions that can help you get paid faster. So first, we'll start with negotiating and understanding your contract. So key is reviewing your payment clauses and what must be provided with your payment application when you turn it in. Oftentimes, the further up the contractual chain you get, you may be required to submit some more documents as opposed to just an invoice that you might see with a material supplier. So make sure you understand what it is that you're expected to turn in each month and have all of that information with you. You would hate to just by an oversight not include all the information you need, and then your payment application may get kicked back to the next month's submission. Also, on the end of reviewing and negotiating your contracts, if the requirements set forth in your contract are vague, you may need to negotiate something more definite just so you understand exactly what it is you're supposed to be submitting. So I don't love clauses that say anything that the contractor deems necessary to support the payment application. You really want to nail down and understand exactly what it is that you're expected to provide, so you don't create a delay in the payment process by simply not providing the required information. Another clause that could be really key in helping you get paid quickly to both negotiate and understand is your dispute resolution clauses. So some people look at these and think only about, suing someone after the fact, at the end of the project, or when you didn't get paid. But these are really important also in getting paid as the project progresses. So what I like to see are requirements that the parties directly negotiate any disputes, perhaps a clause that you submit disputes to an initial decision maker, like the architect. And then also for a requirement that the parties mediate prior to filing arbitration or filing suit. I've mediated many disputes in the middle of a project so that we can put some, payment dispute, a dispute about whether or not a change is compensable or not aside and continue with the project. So if you have those provisions, if you don't have them, you might want to try to get them added in. If they're there and you don't like them, you might want to negotiate the terms. But also key is understanding them and knowing when to pull out that contract and enforce your rights under the contract to follow those dispute resolutions. Another key provision that we talk about with a lot of different topics in the construction industry, but can also be important with regard to getting paid promptly, are notice provisions. So notice provisions are key, and we really talk about them a lot and extensively with regard to protecting your right to get paid, period. If you're required to give notice of change work or delays and that kind of thing as the project is ongoing, you don't want to waive the right to get paid for those things by failing to give proper notice. But also, it's really important to give notice as soon as you can to get the payment process in place as it goes up, the request goes up the contractual chain, so that it doesn't slow down your right to get paid. So the sooner you can give notice, the sooner whoever you've provided notice to, whether it's a subcontractor or a contractor, can pass that along up the contractual chain and get attention on the problem and let the owner know there's going to be additional costs associated with whatever's going on. So take note of the notice requirements, and if you don't need the full time period, go ahead and give it sooner. It doesn't hurt to get eyes on the problem as soon as possible. And I see this sometimes with contractors who think maybe we'll be able to overcome it, and I want to keep everybody happy. I don't want to cause a problem. I don't want to be the problem contractor, and maybe we'll be able to just, accelerate our work a little bit, maybe try to do a little bit different sequencing in our work and overcome whatever problem we had. But if you aren't able to, then you've put yourself behind in getting paid. And if it's not your fault, there's no reason to do that. You should definitely request the compensation that you're due. The last one on this slide is knowing when you can suspend your work. So suspending your work or walking off a job is something that I always advise clients be very wary of. When you're not on the job and someone else is coming in and finishing your work, you really lose a lot of control over the costs associated with that. But it's good to know what your rights are so that you can implement them if you're not getting paid. You can provide the right notice of your intention to stop work if payment isn't made and that kind of thing. So in the next couple of slides, we'll look at some contract clauses that outline specific rights as to when you can suspend work. Before we do that, though, I just want to touch on if your contract does not have clauses that tell you exactly when you can and can't suspend work, then you have an extra layer of risk involved with doing so. And I would refer you back to your payment clauses. So in construction contracts, we typically see pay if paid and pay when paid clauses. And as time goes on, we see more and more pay if paid clauses. Those are clauses that shift the risk of non-payment down the contractual chain. So if your clause has a pay if paid clause that's enforceable, which they are in Kansas, if they're explicit and clearly establish that your right to get paid, that the contractor above you is receipt of payment as a condition precedent to your right to get paid, then you're not going to have the right to suspend your work. However, if you have a pay when paid clause, that does give you the right to suspend work because our courts interpret those clauses to mean payment will be made in a reasonable time, as opposed to you truly are accepting the risk of non-payment from above. So again, always advise you to discuss these things with your attorney before you make a move, but knowing what your contract says about what you have the right to do and what kind of notice you have to give can, again, light a fire under the problem, notify someone that you're not getting paid, and protect your right to get paid and also get you paid faster. Like I said, we have some contracts will have provisions that will explicitly state what you have to do in order to suspend your work on the project. So this is just a sample clause taken from the AIA 105 standard short form of agreement between owner and contractor, and know that there's a similar clause in the subcontractor agreement as well. But if you look at the last 3 to 4 lines with a sentence that starts with, if certification or notification is not made within such 7-day period, and this deals with their ability to review and potentially withhold payment. If you don't get any notice, and then upon additional 7 days notice, you provide written notice to the owner and consultant, you have the right to stop work. So you'd have to be aware of those timelines there. You can't say, oh, we didn't get paid yesterday, we're not showing up tomorrow. You have to wait the appropriate amount of time, provide written notice within the appropriate amount of time, and then wait the appropriate amount of time before you would actually stop work. And again, whether or not you would decide to do this really depends on the situation. Are there issues with your work? Are there complaints about, defective work? Are other contractors or trades out on the project complaining that you're inhibiting their work or delaying their work? These are all things you would want to take into consideration before you take an extreme a remedy like stopping work or walking off a project, but giving notice of your intention to do so can always prompt attention to the fact that you aren't getting paid, and start a discussion and figure out what the problem is. And then here's a sample contract from the consensus docs version of the standard agreement between owner and, they always call it, the constructor. I just use the AIA and the consensus docs both because I like both of them. They're both commonly used throughout the industry. I tend to like the consensus docs better. But a good idea is to use clauses like this if you don't see a clause in your own contract, and put something like this in there. So you'll see this one also has a specific clause for payment delay, and that you have to satisfy all the requirements here. So no fault of the constructor. They don't get a payment from the owner within 7 days after the time the payment's due, then again, upon giving 7 days written notice to the owner, they may stop work. And again, there are similar clauses in the subcontracts, standard form of subcontract, to mirror that right to stop work if the constructor fails to pay the subcontractor. And in the consensus docs, we also see that if there are costs incurred associated with the delay or shutdown, you can also seek an equitable adjustment in the contract price and or the contract time associated with that. So always go to the contract, see what it says about it, and definitely talk to counsel before you employ that method. But again, knowing what you have the right to do is key, so that you can have some real conversations with whoever's not paying you and the repercussions of that. Next topic comes up in almost every webinar I do because it's so important to every aspect of construction, is documentation. So documentation is key in order to both get paid, but also to getting paid faster. So clear and easy to understand claims get paid faster. If they have to get on the phone with you and sort out your documentation and the invoices don't clearly identify that they're for this project or something like that, that can just slow down your ability to get paid. And documentation needs to be contemporaneous in order to be meaningful, and also for courts to recognize it as valuable. So it doesn't do as much good to sit down at the end of the project, go back through your calendar and your text messages and your emails and try to figure out what was going on. You need to be documenting daily and contemporaneously with the occurrences on the project. And this requirement used to be a lot more onerous back in the days when we were manually writing up their dailies and meeting minutes with, on a clipboard. But we all carry these computers in our pockets now, so there's really no excuse for not documenting contemporaneously, even if it means you have to record something and then have it transcribed later. One note I always like to make when we're talking about documentation is, along with the ease of documentation, because we have our cell phones, the easier it is to document and communicate, there's a tendency to become more casual in your communications. So dailies are not a place to complain about your own company. Don't get in text arguments where you're using profanity. What I always like to tell people, if you wouldn't type it up and put it on your company's letterhead and put it in the mail, then don't put it in a text. We really want to always keep in mind that all these documents might end up as exhibits at trial someday, and you don't want to be sitting on a witness stand having to read out an angry text that you sent in haste while you were pretty much just venting, as opposed to truly trying to document the project. It's always a benefit if your documentation is standardized company-wide with consistent internal practices and expectations, so that we don't look at any gaps in documentation and find meaning in them. So if everyone's expected to do the same documentation process and follows through, then we can find meaning in the fact that there wasn't a certain piece of information included, because we know that if the weather had been bad that day, we know they would have written it down, something like that. But if it's not standardized and we're not always following it, then we can't find meaning in those types of gaps of information. So key to remember is that good documentation will help establish the cause of events. It helps preserve your rights and identify the actual costs associated with delays and changes. So it should include relevant information about how the work is being performed and or what is preventing the work from being performed. We would like to note the weather, how many workers you have on site, what work is being performed, if work can't be performed, why, and how much time was spent perhaps demobilizing and remobilizing if you were directed to, move and work on a different building today or something like that. It should show that you properly gave notice of delays and extra costs. So these will all help you both just get paid, but also get you paid faster, because if you've got good documentation, there's a lot less to squabble about down the road. Next up, we'll touch on liens and bonds. So just like with contracts, and I think as I've already mentioned, we have seminars that go deeper into how to make a lien claim and how to pursue a bond claim. But today I just want to focus a little bit more on how you use these things to get paid faster. And key is, just like with other things we've talked about today, is don't wait to assert your claims, and put everyone you can on notice. So there are requirements within the statutes about who has to be included on various notices and liens and included in the lawsuit. But I say get everybody involved from day one and notify them that you're not getting paid, because if the more attention you can bring to your plight of non-payment, the faster it is that someone's going to see that you get paid. So first up, liens. Key is before you start work, please familiarize yourself with the deadlines for filing a lien in the state where your project is located. So the law of the state where the project is located is what will govern. So here in Kansas, as a subcontractor, really anybody who is not an original contractor or sometimes called a general contractor. So anybody who did not contract directly with the fee simple owner of the property, you will have 3 months to file your lien from your last day of work. If you are the original contractor who contracted directly with the fee simple owner, you have 4 months. Now in Kansas, relatively recently, I guess it might have been 15 years ago by now, that we do have the ability to extend that time for filing a lien on commercial projects. So commercial projects only, not residential. You can extend the time to file a lien to 5 months, but in order to do so, you have to file and serve your notice of extension within your original 3 or 4 month deadline. So if you fail to do that, then you do not get the 5 months to file a lien. We find that really beneficial because the notice of extension does not require as much information. It doesn't require as much documentation. So they're really easy to put together yourself. And if you do still have to follow all the statutory requirements as to filing it, you file it with the district court and then serving it. But it's it's an official document that gets filed with the court, and then you can send it out to everybody and let them know you're not getting paid. And we do see clients get paid without having to go all the way through the lien filing process. Not always, if there's a real problem, then that may not do it, but it's a good first step. And I recommend everybody do it anyway. Even if you're ready to file your lien at 3 months, file the notice of extension first. Give yourself the 5 month deadline. That way, if you learn more information that you need to have a good lien, you have time to amend your lien. So in Kansas, we cannot amend defective liens. So there's minor things you can change, but if it's a defect that would mean your lien is unenforceable, you cannot amend it outside of the lien filing timeline. So go ahead and give yourself that extra 5 months on commercial project, or the extra time all the way up to 5 months on commercial projects if you can. And key is don't wait. If you know that you're not getting paid or payment is slow for some reason, don't wait the full 3, 4, or 5 months. Go ahead, send your notices, file your liens, because again, the squeaky wheel is the grease. Before you start work, familiarize yourself with notice requirements in the state where your project is located. In Kansas, this is going to be key for residential projects because there are special requirements of notices that have to be given to homeowners, not as much on commercial projects in Kansas. But wherever you're working, check these things out before you start work. That way, whoever's tracking payment will know when they need to make a call. And this is really important also, for anybody who's working in multiple states. You want to educate your accounts receivable staff on these different requirements in the different states because they vary widely. And then we'll see my key point here: maintain your documentation of the project costs. Like we just talked about, documentation is key to getting paid. And in order to pursue a lien claim, you're going to need to provide documentation of the labor and material and equipment that went into the project and which makes up your lien claim. So maintain that project documentation, have it ready to go when the time comes. And again, like I just said, send notices early. There's really no reason to wait for them. Bonds. So bonds are what we will look to on public projects, property that's owned by public entities. And we see a little bit we see some different situations popping up now and again in various states where it'll be public property, but it's leased to a private entity. And as long as it's not used for public purpose, we'd still may be filing a lien. But if it's a public project entirely, then we're going to have a bond. Also, on private projects, it doesn't hurt to ask if there's a bond, because more and more nowadays, and especially with complicated or more complex financing of projects, large projects, we see owners requiring bonds, and sometimes we even see specialty original contractors requiring specialty large trades to post a bond as well. So check out if there's a bond. I like to do it. I like to tell people to do it right away before you even start work. Find out if there's bonds. That way you've got it in your file and you have it to look to when you need to check out what are the requirements to pursue a claim under this bond. Some people don't like to raise a fuss or get everybody worried and want to wait to get a copy of the bond until they're really sure they're not getting paid. But if there's any hint of slow payment or non-payment, then you really need to get on getting a copy of the bond so you know what the notice requirements are in order to pursue a bond claim and to see if you're even a proper claimant under. So once you get it, review the bond language, know the applicable time deadlines, and again, just like with the lien deadlines, you want your staff who's responsible for flagging problem projects to know what those deadlines are. And then follow all of the requirements within the bond to make a claim. So you have to send the notice as required and the methods required to the people required in order to have a bond claim. But again, don't wait, do it as soon as you can so that you can get everybody's attention on the non-payment problem as quickly as possible. So we're rapidly coming up on the end of our time. So at this point, Diana, do we have any questions in the chat?
No, Leslie, we don't have any questions right now.
Okay. Well, if anybody views this webinar and does have a question about anything we've discussed, my phone number and email address are listed on the screen, and I'm happy to discuss any questions. This is the kind of thing I talk about all day, every day with clients. So happy to discuss any questions you may have. And I know that we would all appreciate it if you could take a moment to review us on Google. You've got a QR code on your screen right now that you can utilize for that purpose. We appreciate your feedback and support. And I think that's it, Diana.
Yes, ma'am. Thank you very much, Leslie, and thank you everyone for your time. Have a good one.